Hello, everyone. Good evening. Thank you for joining us tonight. If this is your first time joining us in this three-part series, thank you so much for being here. You're in for a treat. If you have been hanging in there with us throughout this series, thank you again for coming back. You're in for more treats because we have a great night planned with Matt and Gordon, and they are going to teach you guys a few of the tips and tricks when it comes to special needs trusts. They're going to break down what that means, what that looks like. And we're just fortunate that here at the council, we get to host individuals like this who really take a personal impact on what it looks like to do some life care planning for individuals with special needs. So this is just another one of those components that is very helpful when you're trying to make all these transitions for your individual. So guys, I'm going to let you take it away.
All right. Well, thank you so much for the warm introduction. And I'm going to go to screen share, and we may have another person or two joining us. Sarah Beth, we've got the recording going. Is that correct?
Yes, sir. We are recording. And if anyone has questions, feel free to put your questions in the Q&A and the chat, as we will be able to get to questions as we go. We do have another monitor on this event. So Miss Jamie, thank you for being here. She will help us monitor the Q&A and the chat section as well. But we are recording this. It will be on our website and our YouTube page. So you will be able to go back and watch it later if you missed something or you have questions.
Wonderful. Thank you so much, Sarah Beth. And yes, Jamie Sturchy, our parent advocate and relationship coordinator, is with us this evening is a part of the series. A free follow-up consultation is being made available, and that's as easy as sending an email. Email address will be at the end of the workshop, or responding to one of the pre or post workshop emails that you receive. So several opportunities to respond to take advantage of the free consultation. That usually starts with me, and then we get Matt involved in the process, and we've got kind of a well thought out and thoughtful approach to helping your family deal with all these issues and working together. By the way, the follow-up consultation can be either in person or virtual. And we not only have weekday, but Saturday appointments available to accommodate you. So we're very committed to helping you with these complicated issues and subjects. So with that, I'm going to go to screen share, and we'll get started with this evening's program, which is Special Needs Trusts. And it's very enjoyable to talk about Special Needs Trust because I look at it as a gift to the special needs community. And I think as you learn more about special needs trusts and what they can do for our families, and especially our children and dependents with special needs, I think you'll agree with me that it's definitely a gift. So if I could have a nod of someone's head if the slides are up and showing. Okay, we're looking good. Thanks so much for that. And again, there are bound to be questions as we get into the tall weeds, so to speak, with special needs trusts. So please don't be shy. Chances are others are wondering the same thing that you are and will benefit from your stepping forward with asking a question. Also, if you know of anyone else that's not with us that should be listening, then feel free to forward on the invite for this evening's workshop and have them join in even as we proceed. The gates are wide open, and we want as many families as possible to benefit from this valuable information. So Special Needs Trust, providing for lifetime care and quality of life. Our brief disclosures here. There is a Mass Mutual Trust Company, so we make mention of that. But what we cover this evening is not to be construed as specific tax or legal advice for your situation, because of course we don't have or have not at this point gained a full understanding by which to make specific recommendations. And that's the benefit, of course, of the individual follow-up consultation, which we're providing at no cost to you. That's free as in no cost to you. So, all right, here we go. Special Care is a program sponsored by Mass Mutual. I'm a certified financial planner that participates in the program. And so through that, we help families with the legal, financial, and government benefit issues. And it's certainly an honor and a pleasure to work with Matt and together so that we can address all the issues that we're covering through the series. Okay, moving along, we have in front of us here 10 comprehensive life care planning steps. And this is kind of an early plug for next week because next week is going to focus on life care planning and person-centered planning. And I think you'll very much enjoy next week's program. It's going to show a bit of a timeline in the special needs journey and the important milestones step by step so that families with younger kids can appreciate, parents with older children or even adult siblings can appreciate and see kind of where you're at in the special needs journey. So very cool. And then we're going to be pulling in a lot of the different topics that we've covered throughout the series so that you see how they interrelate and they all come together as a part of a cohesive plan for the future of your loved one with special needs. So there'll be a lot of things covered next week, pulling together so that it, so to speak, makes a lot of sense. On to special needs trusts. There are a variety of reasons for setting up or creating special needs trusts. And so the tent that we pitch pretty much for special needs trusts is very large. And so we pull in individuals with developmental disabilities, which can be caused from a variety of diagnoses, maladies, accidents, etc. So if someone has a developmental or intellectual disability and needs support and help from others, they're certainly a candidate for a special needs trust. Please keep in mind that special needs trusts do not, unlike ABLE accounts, special needs trusts do not require that an individual meet the Social Security definition of disability. And so again, it's a bit of a broader scope. And so we're able to use special needs trusts in situations where maybe for some reason a person simply cannot handle money or funds and they need financial management. To have a special needs trust does not preclude employment. It does not preclude living independently. So again, the swath is pretty broad that we're able to paint with a special needs trust brush. And I have worked in situations where it was mental health, it was bipolar disorder, really a broad variety of things where a special needs trust could be helpful to help protect the person from themselves or help protect them from others that might misuse their funds, especially if it's a settlement or an inheritance. Congenital disabilities such as Down syndrome or muscular dystrophy or things that are traced back to birth from a genetic standpoint. Then traumatic brain injury or spinal cord injury. And it's kind of interesting. I was on a plane this morning coming back from a quick getaway after 15 months of our interesting COVID experience. My wife and I finally decided that for our mental health, even if only a few days, we had to get out of Dodge. And so we were fortunate to have some friends in Florida that said, come see us. So we went down. Well, on the way back today, I was sitting next to an individual at the age of 33 who has had multiple back surgeries, facing neck surgery and or neck, in essence, fusion. And as recently as 2020, last year, was flirting with whether to apply for Social Security disability because it had become difficult for him to get out of bed. I'm very thankful that as of today, he's doing better and was able to manage through the 2-hour plane trip, getting up and down and stretching and doing a variety of things to deal with his discomfort. But none of us know just how close we are to a disabling injury or situation where we're not looking in, but we're inside looking out. And so traumatic brain injury can come from an auto accident or even a fall down a flight of steps. And again, spinal cord injury like the gentleman this morning at just the age of 33. It's interesting how quickly our lives can go south, sometimes prompted by a disability, because this gentleman, because of his medical issues, moved from Colorado back to the Midwest, back to the Midwest where he had support of family because of his health issues. His marriage failed and was seriously evaluating whether he could maintain his employment and so forth. And so these are traumatic changes thrust upon someone. So, again, situations where a special needs trust may be considered. Medical malpractice. Usually that's a situation where something goes bad and there may be litigation and eventually a settlement. And so malpractice situations can create the need for a special needs trust. Personal injury, like I mentioned, auto accidents or motorcycle accidents or a fall or this type of thing. Even if someone is, skiing, water skiing or snow skiing or this type of thing, any of those kinds of accidents that may potentially render a person disabled can bring in the realm of special needs trusts. Manufacturer liability. These are situations where some sort of product or service goes bad. It can be a crib that collapses. It can be an automobile with an electrical issue or a steering issue where the steering locks up and a person has an accident, or lots of things along those lines. Structured settlements where payments come as a result of the settlement in the form of income, and that income may upset benefits, as we discussed in the first of the series, where we're subject to certain limits on earned income and also overall income. And so special needs trusts can sometimes save the day for that. There's inheritance, and inheritance is designed to enhance quality of life. But when there's disability and government benefits involved, it's far more complicated. Receiving a gift, and then of course, Medicaid and Social Security eligibility. So again, pitching a special needs tent is really big because it brings in a lot of people. And so we're going to do a deep dive into special needs trusts this evening and how it's one of the greatest gifts, certainly the Congress and legal community has delivered to us. So if you perhaps, Matt, want to at this point kind of help us as we start the deep dive.
Yep. Thank you, Gordon. Thank you for those introductory remarks, and thank you guys for being with us. We're going to start our conversation on special needs trust with taking a brief step back and doing a mini review from week one when we talked about public benefits. And the reason for that is because, as you'll see, special needs trusts are designed to protect a certain type of public benefits, and those rules dictate why the special needs trusts have to be structured the way that they do. So in order to understand the special needs trust, you do have to understand the benefits as well. So as a review, we've got two types of government benefits. Our first is non-means tested or pension or insurance type benefits as listed in number 1. And our second category is means tested or needs-based benefits as listed in number 2. Our pension or insurance type benefits eligibility is based on some other factor or some factor other than need. So benefits are based on contributions into the program, not based on the person's finances, how much money they make, or how many assets they have. Examples: SSDI, Social Security Disability Insurance, where our eligibility is based on a qualifying work record, and then Medicare, where our eligibility is based on age and or disability. So those are our other factors besides need. Category 2, needs-based. Again, this is based on need. You have low income, low resources, and therefore you need the benefits. So you determine eligibility based on the individual's income and resources, which we talked about in week 1. Examples: SSI, supplemental security income, and then Medicaid, and also the Medicaid waivers. So this is where the special needs trusts come into play, because they allow money or assets to be set aside for the benefit of an individual with special needs without counting as a resource to that person for needs-based benefits. So that's where special needs trusts are applicable, and that's where they apply. That's the connection between the trust and the benefits. So some items to remember as we go through: individuals with special needs who may qualify for both Medicaid and SSI cannot receive those benefits if their assets exceed $2,000. That's our resource limit. So think of $2,000 in the bank as an example. A strategy to get around the $2,000 resource requirement is to place those assets into a special needs trust, because whatever's in the trust doesn't count against that $2,000 number. That's the benefit of having the trust in play. And the assets can include inheritance, gifts, life insurance, retirement accounts. A whole host of items can go into the trust. The special needs trust assets are designed to supplement the needs of the individual with special needs and not jeopardize their eligibility for those needs-based government benefits such as Medicaid, Medicaid waivers, and SSI. But in order to do so, the trust has to be structured correctly and it has to be administered correctly, which we're going to talk about more in a minute. You will hear the term supplement, not supplant, several times tonight. That is important, and we'll go into a little bit more detail on what that means in a few minutes. So you should work with an attorney that is familiar with the special needs trust concept and with creating special needs trusts. So as an example to illustrate this point, not a personal experience, but there are examples of litigation being pursued in the special needs trust context, and the litigation focused exclusively on the word and versus or. The trust had and the argument was it should say or, and vice versa. So it can get very detailed, very particular in terms of the requirements. That's why you want to work with professionals that deal with this day in, day out. So the OBRA 93, that stands for the Omnibus Budget Reconciliation Act of 1993. This is a key law that helped pave the way for where we are today when it comes to special needs trusts. It overhauled Medicaid and authorized parents, grandparents, guardians, and the court to create special needs trusts for individuals who are considered disabled. Prior to OBRA 93, in order to be eligible, you had to spend down your assets to qualify. So this was a breakthrough, very important law that set the stage for the special needs trust concept. So under Medicaid rules, there are limits on the ability of individuals to transfer their own assets to other people for the sole purpose of qualifying for Medicaid. So that's the general rule. When discussing special needs trusts, we are operating under an exception to the general rule. So the general rule states you can't transfer assets for less than fair market value in order to qualify for Medicaid. That's an invalid transfer. It would trigger a transfer penalty and a period of ineligibility. An exception is the special needs trust concept. Example, Medicaid payback trust or self-settled trust, which we're going to talk about. First party trust, those are all terms to describe the same thing. And this allows an individual to receive funds of certain types and go into those trusts without triggering that general rule, without running afoul of those transfer penalties. So because we are operating under an exception, it's important that the trust be properly drafted, because again, if it's not, it could put us back into the general rule, which is not favorable. So important to understand we're operating under an exception to the general rule. So what is a special needs trust? A special needs trust, generally speaking, is an estate planning tool that allows money or assets to be set aside for someone with special needs. And again, as Gordon said, this can be very broad. Doesn't necessarily have to meet the definition of disabled under Social Security rules. So set aside money or assets for someone with special needs without jeopardizing their eligibility for those means tested or needs-based government benefits. So that's, in a nutshell, our general definition. So a special needs trust is a means of enhancing an individual's quality of life beyond the basic food, shelter, and healthcare provided by those government benefits. SSI covers food and shelter expenses. Medicaid provides healthcare coverage, but there are many needs beyond these items which government benefits can't provide for. So it's covering those other items where a special needs trust can be helpful. The special needs trust can be pretty broad, as Gordon mentioned. It can be set up to send a dependent with special needs to camp, take vacations, travel, buy sports equipment, education. A whole host of items can be covered by the trust, and the list goes on and on. If properly drafted, the proceeds placed in the trust do not affect government benefits eligibility. As we said, that's the main benefit, the main reason why we set up the trusts, because if they are done that, set up properly, the funds are not considered available to the beneficiary. And then the funds in the special needs trust are typically invested for growth and income. That's more of a practical point, so that the trust funds are growing and hopefully are outpacing the expenditures, so that the money is always going to be available for the beneficiary. So who should establish a special needs trust? I like to think of this kind of in two categories. Our first category is parents or other family members of an individual with special needs who wish to leave something to that person with special needs upon their passing. And they can either give these assets while they're living or after their death. So that's the first category. Second category of individuals who should establish a special needs trust are individuals with special needs who have excess income and or resources and wish to become eligible or maintain eligibility for those needs-based or means-tested public benefits. So kind of two broad categories of folks that would fall under who should establish a special needs trust. So a caregiver or donor could establish a third-party trust, as an example, for a child, sibling, or loved one with a disability. So a couple of questions that often lead to the creation of a special needs trust are, who will take care of them when I'm gone? Often that's the parents asking this question. And two, how can I pass all or part of my estate to my loved one with special needs without impacting their benefits? So if you're asking one or both of these questions, a special needs trust is probably right for you. So moving to kind of the process on establishing a special needs trust. First step, we want to coordinate our available resources. So we want to evaluate what the individual with special needs has and what his or her sources of income are, if any, as a starting point. And the reason for that is to ensure the continuation of those government benefits. Again, that's our primary goal. That will be accomplished through the creation of the special needs trust. The trust is designed to provide supplemental needs for the beneficiary's lifetime. So as an example, that's supplement, not supplant language. What we mean by that is if the individual is receiving SSI, that is for food and shelter expenses. Whatever the food and shelter expenses are for the person for a given month, those SSI benefits should go to pay for those expenses first. If there's a need beyond what the benefits provide, then the trust can come in and pay for that excess need over what the benefits are covering. The trust should not provide for those first because from Social Security's perspective, they will take the position that, well, we're providing these benefits to you, but you're not using them, therefore you don't need them. And we don't want that to happen. So benefits should supplement, not supplant. The trust should supplement, not supplant our benefits. Our goal, again, is to improve the quality of life. So to provide for those other needs that the government benefits are not providing, other than food, shelter, and those basic healthcare expenses. And then directing our final distributions from the Special Needs Trust. We'll talk about this more when we get to the types of special needs trusts. So getting into a little bit more detail on how a special needs trust works, the trust stipulates how the money contributed to the trust is used for the beneficiary. And typically this is very broadly defined. So the trustee is the person in charge. They're in charge of administering the trust. They're in charge of trust distributions. And generally their authority on trust distributions will be very, very broad, because we want to provide as much flexibility for them to cover as many items for the beneficiary as possible. The trust will include any state-specific language if necessary to be valid under state law, because trusts are a creature of state law. The trust will also name a trustee, again, who is responsible for carrying out the terms of the trust. Naming a trustee is arguably the most important decision in the special needs planning process, because this person, again, will have broad authority over the trust and how the trust is used for the beneficiary. So Gordon will discuss the options for naming a trustee in more detail in a few minutes, but just know that naming a trustee is often one of the first and most important steps that we have to address. The trustee is obligated to act in accordance with the trust provisions. So they have to do what the trust says, which makes sense, and in the best interest of the trust beneficiary, because the trustee is in a fiduciary relationship with the beneficiary. That means they're in a relationship of trust. So it's a legal duties and responsibilities. If they're not doing what they're supposed to do, similar to the guardianship context, then there could be legal liability. And then there are many ways the special needs trust can be created to fit the needs of a particular family. So just know that it's not one size fits all. It can be adjusted to fit the needs of the family.
We do have a comment and a question, guys.
Okay.
This is from Tina. She says, "Thank you, Gordon and Matt, for your information. As Terrence Davis's mom, Tina, I have peace of mind knowing that you have a special needs trust with you guys. My question is, do I have to renew or have this paperwork notarized periodically?"
So I would suggest, so this comes up often. Families ask, well, I had a special needs trust set up 5 years ago or 10 years ago. I would suggest if that describes your situation, to have your documents reviewed just to make sure that they're set up correctly, because again, we talked about the detailed points and making sure that it's done correctly, but also to make sure that it's continuing to suit your needs. So circumstances change. If it was 10 years ago, your circumstances may have changed, and the way the trust is structured may need to be adjusted. So I would recommend periodic reviews, typically every couple years at least. Gordon, anything you want to add on that?
Yeah, I think a review every few years is a great idea. There's no charge for a family to come back in for a review meeting. It's best not to do something and then throw it aside and think it's good for 20 years. And sometimes these changes are not internal, they're external, meaning there's a change in government benefits, or there may be court cases that impact what we've put together. So sometimes you didn't change a thing, but things changed around you. And taking a fresh look at it can make sense. As far as notarizing, typically no, but if as a result of a review, there's some update to either beneficiary or some legal document, et cetera, it's just a matter of, Matt or I or whoever one is working with, getting those changes made. Typically, updating and amending is not an overly expensive process, and it certainly it extends that peace of mind that a person has in having a plan put together. Okay, so another question has popped up, and that is, when can families come in to meet with us? We're making available a free follow-up consultation as a result of participating. And Jamie, if you would be so kind to enter your email address into the chat box. Jamie is our parent advocate and relationship coordinator. And so Jamie will enter her email address, and she coordinates the calendar for scheduling the free follow-up consultations. We typically set aside anywhere from 1 to 1.5 hours for each family. And that can be scheduled during a weekday or even on Saturdays. So we work very hard to accommodate people in their varied schedules. So Jamie, are you able to do that? Hopefully Jamie can get her email into the chat box, and you can simply email her requesting the free follow-up consultation, and she will assist you with scheduling. There is a pre-meeting material that is sent out to you before the meeting. So in case you're curious, there is an appointment confirmation letter. There's a little information form to complete and a brief list of items to gather and bring so that we have everything on hand. If we're meeting in person, you bring all of this with you. If we're meeting by Zoom or virtually, then you would email the information prior to the meeting so that we have it on hand. So, but I'm so glad someone asked, because the reason we remind about the free consultation is knowledge is power, but it becomes power through utilizing it to your advantage in advocating for your child or dependent with special needs. Okay.
We do have another question real quick.
Okay.
This one says, oh, no, I'm sorry. She actually just responded. So Jamie, I'm actually emailing you Tina's info right now. So y'all can connect.
Okay. All right. And then
you answered it. I think we're okay.
Okay. All right. Terrific. Okay. I think we're ready for here. Okay. So let's see here. Let me catch this 13. Okay. Matt, I think, are you still on, please?
Yeah, just a few more slides here. So now talking a little bit about the types of special needs trust. In my mind, I like to structure them with two main differences in mind. So there are two general types, first party and third party. And the two main differences for me to keep them conceptually distinct, keep them clear in my head, I like to look at two main differences. First is whose money is funding the trust. So whose money is going into the trust on the front end, and then on the back end, where does that money go when the trust beneficiary passes away? So those are the two main differences as we go through that we'll point out, because I think they'll help you keep the idea of first party versus third party clear in your head. So we've got first party special needs trust, or sometimes called self-settled or Medicaid payback trust. All of those terms describe the same thing. That's our first party category. The Special Needs Trust Fairness Act isn't its own type of special needs trust, but it did change the laws related to special needs trusts generally, which we'll mention. course, our third-party special needs trust is our other main type. Qualified disability trust, again, another subcategory. Pooled special needs trust could be first party or third party. We'll talk about that in a moment. Then the Miller Trust is a subset, a little bit more specific in terms of applicability. Doesn't come up as often. That primarily arises when the individual with special needs has too much income coming in, and how do we meet the income requirement to maintain eligibility. The other trusts typically focus on a resource issue. Miller Trust focusing more on the income issue. All right, so our first party or self-settled or Medicaid payback trust, all of those terms describing the same thing. Our first main difference, whose money is funding the trust. In the first party category, the self-settled trust is funded with money from the individual with special needs. So this can be examples, personal injury settlement. They were involved in an accident, as Gordon was describing at the beginning, and they received a settlement. That money, if it's used to fund the trust, that's a first party trust, that's their money. Another example, unplanned inheritance. Gordon, can we go back one slide? Just so they can, thank you. Unplanned inheritance. So if a family member passes away and writes your son or daughter with special needs into their will, and they receive $10,000 from that, again, legally speaking, that's their money. That would necessitate the need for a first party special needs trust. So it's individual special needs money that's funding the trust. It can be established by a parent, grandparent, a court-appointed guardian, or the court themselves. And the Special Needs Trust Fairness Act in 2016 also added a competent trust beneficiary, so a competent individual with special needs, and also establish the trust. But don't confuse establishing the trust with funding the trust. Here in the first party trust category, typically it would be a parent or a court or a guardian establishing the trust, but it's actually the individual with special needs' money that is going to fund the trust. So keep that clear. The beneficiary has to meet definition of disability. That's broadly applicable across the board with special needs trusts. The trust is irrevocable, and the beneficiary has to be under age 65 before the trust is established. So a little bit more rules related to the first party special needs trust. Irrevocable just means that the trust can't be terminated or revoked. Our second main difference, so we talked about whose money is going into the first party trust. On the back end, where does the money go when the trust beneficiary passes away? This is our second main difference. In the first party trust context, after the beneficiary passes away, there's what's called a Medicaid payback requirement, which basically means that the state can be reimbursed from the trust for benefits that they paid out on behalf of the trust beneficiary over the course of their lifetime. So, as a follow-up from last week, you may remember that when we discussed stable accounts, we also mentioned that those accounts have a Medicaid payback requirement. However, for stable accounts, that Medicaid payback only applies from the date the account was established and then forward. Here in the first party special needs trust context, the Medicaid payback applies from birth and on. So potentially a much broader time period that we're talking about. And then again, the trust exists for the sole benefit of the disabled beneficiary. So the funds have to be used for the disabled beneficiary's benefit. And again, trust is designed to supplement, not supplant government benefits. That's a key takeaway. That's why we're reinforcing it as we go through. Our third party special needs trust. This is again dependent upon state law. The trust can be set up and funded by anyone other than the trust beneficiary. So that's our first main difference. Whose money is funding the trust. In the third party context, it's anyone except the individual with special needs. So the opposite of the first party. Typically, and the majority of the time, it will be the parents or grandparents of the individual with special needs who are establishing the trust and funding the third-party trust. The beneficiary can be any age. So when we talked about the first-party trust, beneficiary has to be 65 or younger. Here, beneficiary can be any age. The grantor or settlor can be any age as well, with the exception they have to be an adult, so 18 or over. The grantor or settlor is just the person that's establishing the trust. And the grantor either sets the trust up as revocable or irrevocable. Standalone special needs trust, which can be funded at any time, or they can set up a testamentary special needs trust to be funded upon their death. So to kind of break this down a little bit, because that's a lot in one bullet point, our revocable means that the trust can be terminated or revoked, so it can be taken back. Irrevocable means that the trust cannot be terminated or revoked. The trust is its own entity and it will always be out there. A standalone special needs trust means that the trust itself has its own trust document separate from anything else. Contrast that with the testamentary special needs trust. That means that the trust document itself isn't its own document. It's incorporated within your will or within another trust. So that's what the testamentary special needs trust language means there. A little note on funding. You don't have to immediately fund the special needs trust. The trust can remain empty for a period of time. And the reason why that is because the primary source of funding for the special needs trusts are life insurance. And life insurance proceeds obviously aren't going to come into being until the insured passes away. So just to illustrate, funding doesn't have to be immediate. That's often a question that comes up with families. Gordon will touch on that more in terms of funding and life insurance in a few minutes. At the beneficiary's death, so this is our second main difference, there is no Medicaid payback. So the trust assets in the third-party special needs trust, when that beneficiary passes away, the grantor, remember that's the person that is establishing the trust, typically mom and dad, they name in the trust document where those remaining assets go. Typically, if they have other children, they would be listed, or other family members or potentially charities. So that's a key difference. That's why the third party special needs trust context is generally preferred, because we don't have the Medicaid payback and you keep your assets, your money in the family rather than paying the state. And that's the benefit of proactive planning ahead of time, so that you have a plan in place and you're in the third party context rather than being in that unplanned inheritance situation that we talked about a minute ago, where the first party special needs trust with the Medicaid payback would be involved. So, and then lastly, the trust supplements the benefits that the individual with special needs is receiving. And the trust isn't designed, again, to provide the basic needs like food and shelter and healthcare that the government benefits are supposed to cover.
There is a question. It says, money from the life insurance, is that first or third? Is it better to have beneficiary other than person who then funds the special needs trust with the money to avoid the Medicaid payback?
So Sarah, about the first part of that question, is it first or third, the life insurance? So typically we're in the context of if mom or dad have a life insurance policy, presumably it's insuring their life. And upon their passing, if they list the special needs trust as the beneficiary, again, that's in our third party context. What was the second half of the question again?
The second half says, where'd it go? Sorry, I just clicked off of it somehow. Oh, then she said maybe Gordon's going to answer this question.
Okay, I will revisit that area. So I certainly agree with what Matt says. Generally speaking, life insurance is third party and there's no Medicaid payback. The exception is when beneficiaries are out of date and the consumer with special needs or disability is actually designated, or there's life insurance and there's no beneficiary and it goes to the estate and the parent has no estate plan in place and the laws of intestacy kick in and the state drives assets to the disabled party. So the answer to the question is maybe a little more complicated, but with planning, there rarely is a reason why life insurance would have to be first party. Again, with good planning, in nearly all cases, life insurance can avoid the Medicaid payback.
Thank you for that.
All right. I think we will move forward. So now we talk about the Qualified Disability Trust. Again, a trust designed for a beneficiary who has disabilities. Important point, Qualified Disability Trust does qualify for a $4,300 tax exemption, which is more than an ordinary trust, which would be $600. That's one of the benefits of having a Qualified Disability Trust. If it's applicable, how does a trust become eligible for this Qualified Disability Trust designation? There are several criteria. The first is the trust has to be irrevocable, which means it can't be terminated, can't be revoked. Limited amendments as well. Trust must be established for the sole benefit of the trust beneficiary, the person with special needs. The disabled beneficiary must be under the age of 65 at the time the trust is established. So again, we have an age restriction, and the beneficiary has to have a disability that is included in the definition of disabled under the Social Security Act. So a little bit more restrictive on our definition of disability. So a little note on those Qualified Disability Trusts. Continuing that, so the trust must be a third-party trust funded entirely from someone other than the disabled beneficiary. Again, you should consult with a special needs attorney or a CPA or a professional like Gordon if the person is funding the trust during his or her lifetime and is also serving as trustee. Again, it's important to have professionals that are familiar with these aspects because it's very detailed, very specific. You want to be sure you're doing the right thing and the trust is going to meet your needs and meet all of the requirements. Trust, again, must be for the sole benefit of the trust beneficiary, the person with special needs. No other person or entity can benefit from the trust during the lifetime of the disabled beneficiary. That's our sole benefit rule. On the death of the beneficiary, the trust assets pass to the remainder of beneficiaries. They do not have to be disabled. So that's where does the money go when the trust beneficiary passes away. Trust must be established and funded before the individual turns 65, so our age requirement, and the beneficiary has to be disabled under the Social Security Act. So they have to meet that definition of disability or receive SSI or SSDI benefits. Because again, if they're receiving SSI or SSDI benefits, they're already going to meet the definition of disability under Social Security, because that's a prerequisite to being eligible for those benefits. As most special needs trusts are funded with the parent's assets, this includes life insurance, gifts from other family members, they can be established and treated as a qualified disability trust, again, if they're meeting these requirements. And this makes the special needs trust an even more valuable planning tool, again, mainly for that exemption that we talked about, $4,300, which is higher than what ordinarily would be. So from a tax perspective, some benefits there.
All right, Matt, thank you so much. The reason we spend a little bit of time on qualified disability trusts is often trusts get a bum rap based on tax rates, and you can get into higher tax rates more quickly with a trust than an individual. However, again, the exception, the carve out that we have talked about more than once this evening, a hard fought in Congress, is this qualified disability trust. So if we can jump through just a few hoops, then the first 4,300 again of dividends, interest, and capital gains can be free from taxation. And this can enable the trust to be more tax beneficial than an individual situation. So we're certainly very pleased to bring that information to you. Let's spend just a moment on pooled special needs trusts. Pooled trusts are where an individual can have a special needs trust, but it's not unique to them. There's typically one or perhaps a couple of special needs trusts that are set up by a nonprofit, such as Life Plans of Kentucky or ARC of Indiana, for those of you that may be on the Indiana side of the river. But a nonprofit, a 501c3, can set up a pooled trust and make that option available. So you, in essence, establish an account in the pooled trust. Everyone has, as I said, the same trust guidelines, so they're not into customizing, but there are some situations where a pooled trust can be helpful. Upon death of the trust beneficiary, remaining assets in the nonprofit special needs trust or pooled trust can go to Medicaid or to the family, depending upon what type of special needs trust or design. So some nonprofits have both first party and third party pooled trusts. The pooled trust serves as the trust and the nonprofit as the trustee. So there's some element of giving up control from a family standpoint, but in the bottom bullet point, this type of trust can be less expensive, not overwhelmingly so. Usually the difference is a matter of a few $100s, not thousands. And so oftentimes families prefer to have an attorney draft the trust so that the parents, as Matt was saying, can be the trustee, and they can have more influence both in setting up the trust and then being the trustee going forward. But when family members are not available to serve as trustee or where funds are limited, and we want the pool trust or the nonprofit to be careful in terms of distributing monies to make them last, this type of thing, there are some situations where the pool trust can be helpful. Majority of people have an attorney drafted trust, but I'm keen to making sure we get to the finish line with the family, and in some cases, a pool trust helps us get there. I think perhaps a question may have come up. Let's see here, or not. Okay, maybe not. All righty, we're going to we're going to move on to the Miller Trust that Matt spoke briefly of, and we've got a couple of examples, so I'm going to enjoy sharing about those. But in some situations, an individual with a disability needs more than one special needs trust. That does not make the process that much more expensive. The special needs planning that we're talking about this evening is not financially crushing. Again, I repeat, it is not financially crushing. In many cases, a payment plan can be worked out for fees to make them affordable. This is more about your family and your loved one with special needs than it is about our bottom line. And so because of our keen interest in helping families and our passion to serve and to be supportive, we figure out a way. We want to get families through the process, and if a family is open to being helped, we can get that done. Now, Miller Trusts are something newer to the special needs community. They've been around for a while, but most often used for seniors or elderly people in managing government benefits relative to assisted living or skilled care nursing. But we as a special needs community have woken up to it, and we've responded saying, well, what about us? And the answer is, what about us? And we can use Miller Trusts They were a part of the carve out from OBRA 93, the Omnibus Budget Reconciliation Act of 1993, that brought about the D4A or self-settled trusts that we've talked about before. So it's an irrevocable trust set up to receive monthly income in excess of the $2,382 per month allowed to maintain disability Medicaid and Medicaid waiver services. So let's just look at a couple of examples, because you may be sitting there thinking, well, shoot, Bobby or Susie will never see $2,400. This really doesn't apply to us. But usually it becomes an issue when adult child benefits are involved, which we talked about in the first session. So example one is Daniel has special needs and is employed. So that's a happy thing. He's got a job. He's earning $1,000 per month. And we are starting to see individuals with special needs earning at this level. I just was on the phone with someone who works for Special Olympics, and their adult child has employment part-time and is earning $1,000 per month. So we do see it. In some instances, the adult child may be earning at a rate of $10 or $12 per hour. And if you go to do the math, you'll find that it doesn't take more than part-time employment to reach the $1,000 a month. So in this case, Daniel receives $458 in Social Security disability benefits and $336 of SSI. So you might wonder, how could somebody earning $1,000 a month still get any SSI? And the answer is the formula that we talked about in session one, where we indicated the first $85 is waived. And after that, it's a dollar reduction for each dollar of reduction for each $2 of earnings. And so the answer to the question is, it is possible to earn $1,000 a month and still have a little bit of SSI. So if you add these numbers together, this person is bringing in a total of almost $1,800 per month between the combination of SSI, SSDI, and earned income. So in this case, everything is good. His earned income, Daniel's earned income, is under that SGA limit we've talked about of $1,310 per month. So he's not violating the Social Security earned income limit. And his total income at $1,794 is under $2,382. So you heard me right. It's possible for this person, for this Daniel, to have $1,000 in earned income and $458 in SSDI, $336 in SSI, for a total of $1,794 per month, and maintain all of his benefits. Benefits including the Social Security, Medicaid, Medicaid waiver services, etc. So if he keeps his resources under $2,000, which is necessary for both SSI and Medicaid, all is good. But things changed. He didn't ask them to change, but they changed because his dad decided he had had enough at the plant and turned in his letter and said, that's it, I'm done, I'm going to retire. So COVID was it. He said, enough of this hooey, I quit, I'm done, I'm retiring. So he retired and started drawing Social Security retirement benefits. Well, this made Daniel eligible to draw off of his dad. And you might recall the criteria for drawing off of a parent is that a parent die, become disabled, or start drawing Social Security retirement benefits. So bingo, Daniel's dad starts drawing Social Security retirement. So that triggers it. In addition to that, the consumer needs to be disabled under the age of 22, the origin of it, before age 22, and to be under the $1,310 per month, and in most cases to have remained single. So Daniel fits all that criteria, and he starts drawing a total Social Security benefit of $1,500. So no more SSI, but the benefit between himself and his dad, he's now drawing $1,500 a month in Social Security. So now he's got a problem, because with $1,000 in earned income and $1,500 in Social Security, he's at $2,500 per month, and he has exceeded the $2,382 monthly benefit to maintain Medicaid eligibility. He's over it by $108 per month. So you might see, might react with no big deal. It's only $108 a month. Surely they'll ignore that. And surely you are wrong. Social Security is not known to waive or overlook much. So this could result in a loss of Medicaid and waiver services. And so for this situation, Daniel would want to consider setting up a Miller Trust to receive that at least $108 per month. And if he does that, then he is seen as being under the $2,382 and he gets to keep everything. So that's where a Miller Trust can come in. It doesn't solve resource issues, but it certainly does solve income issues like Daniel's. So as a result of setting up a Miller Trust and sweeping the 108 or more per month into the Miller Trust, Daniel gets to keep everything. The only thing he lost in this whole process was his SSI, but that was replaced with a higher Social Security disability benefit. So using a Miller Trust, the $2,500 a month is okay, and he can have $2,500 a month coming in while maintaining his Social Security benefits, his job and earned income, his Medicaid for healthcare and waiver services. Example 2, Ted has special needs and both parents die in an auto accident. He works part-time, earning $700 per month. So he's not doing quite as well as Daniel in example number 1. But this is not a parent retiring. This is parents deceased. And oftentimes survivor benefits for an adult child with special needs are more significant than the benefits when the parent retires. So in this case, Ted was calculated to be eligible for $1,800 per month. Well, you quickly do the math and you can see he's right up to that $2,500 a month, just like Daniel. Same problem as Daniel. We need to look at a Miller Trust for that situation if he is to retain all of his benefits. So these are, again, examples of where a Miller Trust can literally save the day. Most often, when there's some amount of employment combined with drawing off of a parent as a result of a parent's death, disability, or retirement. Okay, so here we're talking about who one might want to select as a trustee. And it can be a family member. The trustee will make distribution decisions, meaning what's the trust going to pay for? What social activities is it going to sponsor? And a trust, if it's adequately funded, can buy a condo, it can provide transportation, it can provide any number of social activities, going to the beach, going to Disney World, going on a cruise, enhancement activities such as going to camp, hiring a personal trainer, going to the gym, purchasing clothing. I mean, the list goes on, going back to school, a lot of things. The trustee typically is responsible for, though frequently gets help, as I manage many millions of dollars of trust funds, but the trustee is ultimately responsible for what's in the trust investments, that there's some amount of record keeping, and tax returns are filed as appropriate. So this time of year, actually for about the last 60 days, I have received, of course, a litany of emails with what's the tax ID number of the trust, and do we need to file a tax return, and can I get help in filing a tax return for the trust, and how much did we spend from the trust last year, and on and on. So it goes with the territory. So I, as an example, frequently serve as an investment manager, hand selecting investment for a trust so that we can grow the trust so that it can do more for the family member with special needs. So I think I may have mentioned last week that an example would be a young man with a traumatic brain injury, and through carefully managing investments in his trust, we've grown the trust. In fact, in the last 18 months, it's grown by over $100,000. And so he gets a monthly allowance to maintain his quality of life, and growing the trust helps make sure that he won't run out of money. Medicaid and social workers are involved for the extent to which benefits or services are needed for the trust beneficiary. The social worker, the case manager, in some cases may also help inform or keep the trustee updated so that the trust functions in a manner appropriate based on the nature of needs that the trust beneficiary has. Now, I'm often asked questions such as, does money sit in there like a bank account? Do you set up a trust bank account, or what do you do? And the answer is you could set up a trust bank account, but if our objective again is for funds over time to grow, then it can be helpful to have a carefully selected investment portfolio. I'm also asked, how can we access funds in the trust? It's great that it's growing, but if you can't get your hands on the money, what good is it? And the answer is a checkbook is frequently set up for the trust so that checks can be written to pay bills. Electronic transfer can be established, and also standing instructions and recurring bills can be electronically paid, et cetera. So pretty much anything you would think of an individual doing with their personal situation, we can do at a trust level for the trust beneficiary. Okay, methods of funding. Another reason why it's important to plan, because a trust may look good on paper, but what's really going to make the trust sing is what flows into it, meaning what resources are going to be in the trust that can pay for and do for the trust beneficiary. So we see a lot of gifting being done, gifting anywhere from a stock like Amazon that some grandparent bought at 10,000 and now it's worth 30,000 or something. So some family members are cashing out, knowing that the stock market is at a record high, or seeking to transfer stock in kind, stock or mutual funds in kind into the trust for a tax benefit, transferring the basis of their stock or securities to the trust so that they avoid having to declare capital gains or the investment income on their taxes. So there are definitely tax advantages to making gifts to a special needs trust, and that is often of interest to especially grandparents, sometimes parents, aunts, uncles, godparents, etc. Life insurance we touched on briefly a moment ago. The life insurance being a beneficiary, the insurance company will literally cut a check directly to the trust. And if there's not a trust account set up already, the trustee, with the help of someone like myself, will set up a trust account. And then the life insurance proceeds can be deposited into the trust. Retirement funds via beneficiary. For many of us, most of our savings is in the form of retirement funds because we participated over a period of years in a 401k, a simple, a SEP, a 403b, deferred compensation, Roth, traditional IRA, et cetera. And the tax advantages drew us to it. And so we put money in it over the years. We might have had an employer match. But eventually when something happens to us, if it's retirement, we're going to draw monies out of the retirement account. But if God calls us home, then what's left in the retirement account will go to the named beneficiary. And if there is no beneficiary named, that may spell bad news. So a part of the process that we go through with families is to make sure or make certain that there are instructions on all life insurance, retirement accounts, et cetera. So it's very clear when the account holder passes where the funds are to go or how they are to be handled. And this is important in light of the Secure Act that just passed last year in 2020, where it matters who the beneficiaries are on your 401ks, IRAs, et cetera. In fact, it's more important than ever. And these are things that we get into during the individual consultation, kind of like who should receive the funds. Typically, if married, a spouse to begin with, but beyond that, it's not a slam dunk. And having some advice regarding your contingent or secondary beneficiaries can be extremely helpful. Investment accounts via transfer on death. Most people are not aware that it is possible to put instructions on a mutual fund account or an investment account as to what's to happen with that account when something happens to them. So we help families with that. CDs via payable on death instructions. Not a lot of money in CDs at this point. The interest rates are so low. And then also the gift of or leaving of property to the special needs trust. So there are lots of ways to get very small money to the very large money into a special needs trust, often with tax advantages. So here you see caregiver, grandparent, godparent, friend, or even a GoFundMe account can contribute lump sum payments to fund the trust. So it can be lump sum via, again, inheritance, writing a large check, lump sum payments, or events to get monies in the trust, including appreciated investments, as we were talking about a moment ago, and then annual or monthly, putting the trust on the payroll. Maybe a parent or a representative payee is receiving so much a month to assist with expenses for the consumer or family member with special needs. And there's certainly nothing wrong with the provider of food and shelter receiving Social Security payments to decide as they're reimbursed for those expenses to put part of it into a special needs trust account. So we set up special needs trust accounts all the time. Sometimes it's only 25 or 50 a month going into one of these. In other cases, a much larger sum. But special needs knows no limits, and we're here to help families no matter their financial circumstances. Life insurance, again, via beneficiary. Some life insurance is lump sum where a single check is written and life insurance is secured. Other life insurance is paid for on like a monthly basis. And the life insurance via beneficiary can go to the trust. We just have to be very careful as to both how the trust is set up and how the beneficiaries are done. But it's possible via beneficiary to know while you're living that if something happens to you, there are resources that will be placed in the trust to fund it. This shows different types of life insurance, and we'll touch on that. Let me see here. Yeah, okay. I guess we'll do that now. So some of you have term life insurance. That's life insurance that may last for a few years, maybe 5 years, 10 years, that type of thing. So beneficiary can be set up to go to the trust if a person were to die during the prescribed period. There's universal life, there's whole life, permanent coverage, other types, again, by beneficiary. And in fact, the special needs trust can also own the life insurance. So if a parent or someone wants to assign or change ownership to the trust, then the trust can pay the life insurance premiums and receive the trust proceeds, or excuse me, the life insurance proceeds upon the death of the insured. The life insurance funds can fund the trust in the future upon the death of a parent, as an example. And life insurance proceeds are typically paid to the special needs trust free of taxation. Okay. Question: is there a way that a CD's POD to a special needs trust be transferred to the trust if the owner of the CD needs to qualify for Medicaid to protect assets? I'm thinking of a situation where the owner of the CDs needs nursing home care. So the answer is, when let's say the parent needs care and the parent has assets that would otherwise block their eligibility for Medicaid is typically what's being sought after in these situations. And the answer is actually yes. If one does have a child or a grandchild with special needs, there are some circumstances under which assets can literally be offloaded from the individual seeking nursing home care or Medicaid benefits into a special needs trust. This is not something to attempt on your own. It is only something to consider when working with someone like Matt and myself. But the answer to the question is, in some cases, it is not necessary for a parent to be subject to a spend down to qualify for Medicaid or nursing home care, assisted living care, this type of thing, if they have a child with special needs. So in a carefully crafted plan, it may be possible for their $100,000 or $200,000 of assets to be placed into a special needs trust and make them eligible in the process for Medicaid without being subject to a period of ineligibility. And this is really cutting edge stuff. And that's because special needs trusts have only been around for approximately 27 years. And so we're just starting to get to the point where parents are reaching that age where considerations for care for themselves are a factor. So know that it's possible, and it's something certainly that we can discuss more in the individual free follow-up consultation. All right. See if we can get this moving again. I like it when it moves. Okay. All right, I think, Matt, we're ready for you to jump back in if you'd be so kind.
Okay. So here we've got just a kind of a breakdown, splitting the sources, so where the money is coming from and what is covered by them. So on the left, we have our benefits side, so Social Security benefits, Medicaid, Medicare, what those benefits are primarily geared to cover. So again, basic personal needs, food, shelter, our healthcare expenses, things like that. On the other side, the Special Needs Trust to kind of illustrate that supplement, not supplant idea. Again, Special Needs Trust can cover all those other additional needs that the benefits aren't covering, and also those needs in excess that the benefits aren't providing. So if, again, back to our example from earlier, if SSI isn't covering all the food and shelter expenses for the beneficiary each month, the trust can pay for that additional need after the SSI has been spent. So this just kind of gives you a little breakdown there.
Okay.
All right, so services to expect from a corporate or professional trustee. So most of the time in the Special Needs Trust context, a parent or both parents or a family member is going to serve as trustee or successor trustee. However, a corporate or professional trustee could be suitable if you don't have very many options in your family, or your family members may not be good with money, may have had histories of bankruptcies, things like that, where they may not be a suitable candidate to serve as trustee. That could arise, the need could arise for a corporate or professional trustee in those examples. So the services from them, they would provide full trust accountings and asset reporting to the donor, the person contributing money to the trust, the beneficiaries, and other relevant parties. They would prepare and file the required tax returns for the trust. Can be an area that's confusing, especially if you're not familiar with it. So that's a good benefit of having a corporate or professional trustee. A relationship manager is often assigned, and the point of contact between you and the professional trustee, so who you communicate routinely. Access to secure website to check the status of the trust, how much is in it, how much has been spent, things like that. Arrange for professional money or investment management. So again, those carefully specified investments so that we can hopefully have the trust growing so that we don't run out of money down the road. And then also the professional or corporate trustee can make disbursements or pay bills as needed or as required. So our three-step process for setting up a special needs trust, what does that look like? Step one is what I would call the gathering information step. So we're gathering information regarding the trust beneficiary, the trustee and successor trustee, the grantor, the person establishing or persons establishing the trust, any remainder beneficiaries. We're also gathering information on the funding sources, when we're going to fund the trust, so the timing issue. So we're gathering all of this information. And once we have that, we're working on assembling the trust based on that information. So step one, gathering information. Our step two, once we've got all our information together, we've started to piece together the trust document. That is our review stage. So here, the trustee, most often the parents, However, sometimes if, again, we're using that professional trustee or a trust company, um, they will request a review of the trust document and a list of the trust assets that are going to be funding the trust. They'll review the documents to confirm that the trust meets their requirements and that they can efficiently administer the trust according to the trust provisions. So the trust company reviews it before formally accepting the role as trustee. The trust company would be available to discuss the terms of the trust with the grantor and or their attorney. And if any corrections or changes are needed, they can work on that again before the trust is actually signed and put into place. And also the parents or the trustee, if we don't have the professional trustee involved, would review the trust documents and the drafts to make sure everything is the way that it needs to be. And also it provides an opportunity for them to ask any questions. So as an example, I always provide the final drafts to clients so that they can review them. They can look them over for accuracy. And also, if they have questions about certain things, we can go ahead and answer those before they come in to sign the documents so that they don't come in and see the documents wholesale for the first time and be expected to sign them that same day. So that's our step 2, reviewing the documents. And then step 3 is our signing stage. So this is where we've gathered the information, we've looked over the drafts, everything's ready to go. Now we're actually going to sign and execute the trust documents. So after the review, after the trust company's acceptance, or if it's a family member who is not the grantor, so a situation where the parents are establishing the trust, but may not necessarily be the initial trustees, very rare. In that instance, the trustee would have to accept that role, just like the professional trust company accepts the role of trustee. They would all sign the trust document, or the investment company would also open up a trust account, assuming it was going to be funded immediately. And then that investment program, if it is going to be funded immediately, would be defined by the trustee and the organization that you're working with. As an example, with an individual like Gordon, an investment advisor, to provide advice on how the trust should be invested.
Okay, all right, thanks, Matt. Fundamental principle for a fiduciary. Those with responsibility to invest money for others should act with prudence, discretion, and intelligence and regard for the safety of capital as well as income. So I know in the trust assets that I manage, I labor over them because I realize the direct impact that the results will have on the quality of life for those that are depending upon that. So again, important to work with individuals that have expertise in these areas, certainly as well as a heart for this work. So the role of a financial professional is to understand the financial needs of the individual and how social, medical, and legal needs impact the life care plan. Again, life care planning, the topic of next week's session. Provide a financial need analysis, coordinate financial strategies with the attorney like Matt and other professionals on the team. Other financial options that make the most sense based on needs, work with an attorney to help ensure that benefits such as Medicaid and SSI won't be jeopardized. And know the questions to ask about the current and future needs, help the caregiver maintain the lifestyle. It's all about their quality of life. So of course, the special care program at MassMutual that I participated helps with both the process, working with an attorney like Matt, who gets and understands the legal side of special needs planning, and then how we're going to fund the trust that Matt helps set up for you. So it's very much a partnering or a teaming approach to helping families get through the process. Here you see our information, and getting your free follow-up consultation is as easy as sending an email. If you'll email me, I'll forward it on to Jamie Sturchey, our relationship coordinator, and our parent advocate, that type of thing, but there's no cost. And we're happy to do that on either a in-person basis or by virtual, like Zoom, that type of thing. So ghomes@financialguide.com. And then again, there's a process that we go through where an initial consultation, referral to Matt, and back and forth to get all of these issues all stitched together so that we have an excellent plan for your family and your loved one with special needs. I think we have just a little bit of time left, and I'm going to yield back the sharing. And at this point, with about 5 minutes left, questions that anybody has about anything that we've covered, any of the special needs trusts that we've talked about. And okay. All right.
Doesn't look like anybody has any.
Okay. All right. We'll stick around for just a couple of minutes if anyone comes up with a question. In the meantime, please look for a follow-up email to this evening's workshop, and know that next Tuesday will be the fourth and final in the installment as May starts coming to an end. And so please participate. Again, we so appreciate so many being loyal to stay with us one week after another. Invite others to join in as well. Looks like someone asked, can you stipulate that your loved one stays in Kentucky so that a waiver is not lost? Well, probably the person that has the most to say about where the family member with special needs stays is the guardian. So if you have adult guardianship for your loved one with special needs, then your estate plan can provide for who replaces you. In a two-parent situation where one parent is lost, as we talked about last week, you may want to go to court and get an adult sibling on there as a co-guardian. But so who you select as guardian is going to have an impact. And then also the letter of intent, which is a non-legal document, is your opportunity of letting it be known what you intend to happen. So that won't prevent them from leaving the state, certainly. However, if you have a Michelle P. or SCO waiver or something like that, there's a good chance the state they're moving to is not going to be as generous. And advisors, of course, will counsel the family on making careful decisions in that regard. Anything you'd want to add, Matt?
Yeah, I would just say the only other situation to think about is if the parents have a minor child with special needs where formal guardianship isn't available because the child isn't old enough and something happens to them. Typically, this would be where in your wills, you would provide a recommendation to the court on who you want to take over the care, just as kind of Gordon was saying, expressing your intentions and your desires. That would be another place where you would plug in that information. While it's not necessarily legally binding, it does provide some good insight to everyone on what your thoughts and your wishes are. And then hopefully those will be followed. So kind of touching on the situation where the child isn't old enough to have a formal guardian, where they're under 18. So just keep that in mind.
All righty. Well, it's right at 8 o'clock. We will reconvene next Tuesday at 6:30.
Gordon, we do have two other questions that just came in.
Okay, yeah, please.
One says, what disqualifies a disabled person on SSI from adult child benefits? My son worked for a couple of years in early adulthood, but is autistic and was in special ed in school.
Okay, well, there are several criteria, and it would really be a good conversation to have in an individual consultation. But the disability being identified prior to the age of 22, that can be either in the form of qualifying for SSI before 22 or simply medical records, et cetera. But the disability needs to date back prior to age 22. Second of all, you mentioned that he did some work, which is wonderful. We will just need to look at what work he did and what earnings were earned and in what time frame, as to whether he potentially exceeded the substantial gainful activity limit at the time. So again, something we can look at it on an individual basis. One of the best ways to determine what one's earnings history is and whether it's a potential issue or not is to go on the Social Security website and request the Social Security report, which is a 4-page report that's free and available to anyone. And so that's a good start, but we can figure that out. And the third item to be eligible would be that he had remained single. So, most, certainly not all, but most of our young people do eventually become eligible for adult child benefits. And so then, as we've discussed before, it becomes a careful consideration for parents deciding about retirement and when to draw retirement benefits and the implications on the adult child benefit. So great question. Encourage you to take advantage of the free consultation, but unless the kid got married, had no Social Security until after age 22, and when they worked, they earned a lot of money, chances are there's a good chance they'll be eligible for adult child benefits. Mom passed away, sister has paid his bills till she could become payee. Account past 2,000. Can we now write a check to the sister to pay her back and get the account under 2,000? Have paid bills since February. Yes, the sister could certainly be reimbursed depending upon the age of the consumer. There may or may not even be SSI involved. It may be Social Security disability. So Social Security disability or adult child benefits. So the Mary Baker question, please take advantage of the free consultation so that we can look at the nature of nature of the funds. But generally, yes, the sister could be reimbursed to get it down under $2,000, and it may, or the fact that it went above 2,000 may or may not be an issue depending upon the type of Social Security benefits. Social Security will determine a period of ineligibility potentially and go back. Medicaid typically does not. But again, things to carefully consider. Matt and I both look forward to meeting with many of you on an individual basis to dig into these very specific questions and to be additionally helpful. With that, we've gone past 8 o'clock, unless there's some additional question that's popped in there. We appreciate everybody participating this evening. We very much look forward to completing the series next Tuesday evening. If for any reason you're unable to be here, the sessions are being recorded, posted to the website, as Sarah Beth indicated, and there are workshops being done for other organizations, so you might be able to participate in those and those as well. Most of upcoming workshops are on my website, the www.gordonfholmes.com. So check there for other workshops, etc. And we will see everyone next week.
Have a great night, everyone. Thank you.
Thank you.